Minister of Rural Development and Local Government.
Thank you, Mr. Vice President. Mr. Vice President, it gives me great pleasure to wind up this debate on what I think to be one of the most important pieces of law that I have had the privilege of piloting. Mr. Vice President, the material before us is one that has received, as the record now shows, significant contribution. We have had decades of consideration of the law. I referred to the fact that it was the Exchequer and Audit Act in 1959 in its passage that really saw the re-centralization of local government, whereas the county councils had their proper function and a degree of almost full autonomy with the ability to manage all things that were within the respective counties. The Exchequer and Audit Act really was the single piece of law that brought life into central government managing all that was under the purview of local government. Now, Mr. Vice President, it's important to ask ourselves, how has that worked for us? And if we're truthful about the experience, I think that everybody in this august chamber can agree with everyone on the outside of this chamber that local government has not been allowed to perform in the fashion that we wish it to perform. It's why in piloting the bill, I started off by saying, dare to dream and just start. Mr. Vice President, I wish to thank the honorable members of the Senate for their fulsome contributions across the three benches. Because, Mr. Vice President, even though one may be tempted to just simply castigate the opposition and say, look, they don't support, so let's not speak to them, the fact is that the opposition has brought proper reflection to some of the difficulties in local government. The members of the independent bench have brought some very targeted focus, which I hope to address as well. But I wish to also thank my colleagues on the government bench. And in particular today, I wish to say to my learned friend, my colleague, the Minister of Agriculture, the Honorable Senator Haji Kazim Hussain, that he has left an indelible mark in the Ministry of Rural Development and Local Government, and one that is very hard to even think of surpassing in his humility and in the exercise of his functions as a minister in preparing us for today's debate. And I really, genuinely reflect upon this, not because of the work that I've seen inside of the ministry, but because each and every weekend I have the pleasure of working with a different corporation as we survey and clean Trinidad and Tobago in preparation for this law, and everybody gives the same testimony of my colleague and friend, my brother Kazim Hussain. Mr. Vice President, I wish to also thank the Honorable Attorney General, Mr. Reginald Armour of Senior Counsel, for targeting on the government side the purpose of today's law. And permit me one moment to reflect upon a quotation which I was going to give myself, coming from the works of Sheila Solomon. And allow me to say, Mr. Vice President, that in the treaties and work that I was privileged to receive, and material which speaks to the power of listening those words immortalized by Sheila Solomon in her written contributions to the development of Trinidad and Tobago, it's by no mistake that her son-in-law finds himself here as the Attorney General of the Republic of Trinidad and Tobago, Reginald Armour, because he too has taken up the mantle of public service. So permit me, Mr. Vice President, to say a special thank you to the Solomon family, be it Frank Solomon, Dennis Solomon, Sheila Solomon, or the servants that they bore in their ways and forms across the panoply of Trinidad and Tobago's public service. So, Mr. Vice President, let's jump to the contributions and let's thematically arrange them. We heard our colleagues speak to a few issues which are in common. Number one, the issue of property tax. Number two, the role and function of the Minister of Finance. Number three, whether this is devolution of power or is it in fact centralization of power as it relates in particular to the role of the Minister of Finance. We also heard about the need for transitional measures. And then the fifth category that you can throw together is the specific tailor-made observations in respect of the laws as set out. Because, Mr. Vice President, we are with several schedules in consideration. The bill itself proposes amending 9 laws and various regulations under those laws, but we're really looking at approximately 111 amendments. And those 111 amendments, the large part in Clause 3 treats with the Municipal Corporations Act. So let's jump to the thematic areas. As many senators proposed that there was a degree of clarification required. Let's start off with the issue of property taxes. Clause 3 of the bill proposes a reintroduction of the concept of land and building taxes, now called property taxes under our law, and those taxes are to find themselves in a reinstitution of Part 5 of the Municipal Corporations Act. And Part 5 of the Municipal Corporations Act is where the old land and building taxes used to live as a feature of law. Part 5 substituted the inclusion of property tax. And several members correctly observed that the bill right now is proposing the corporations to receive the fruit of property tax. Members have reflected upon the fact that property tax in the new section 76 onward that we'll add, that property tax under the Municipal Corporations Act, the new Part 5, focuses upon residential taxes. And yes, honorable senators are correct, rural areas with sparse number of residents will be at a disadvantage from more urbanized or centralized areas. Let's put it into context. A couple weekends ago, I was in Streatham Lodge Cemetery. 22 acres of cemetery with 230 CPEP workers cutting grass that was 16 feet high. That cemetery represents the size of the borough of Arima. Let me repeat that. One cemetery at Streatham Lodge is the size of the entire borough of Arima. So you're getting an idea of density. You look at the San Fernando City Corporation, you will see a similar density. You look at Port of Spain. So yes, let's accept that property tax from a residential purpose under Part 5, as it is proposed to be inserted after Section 75 of the law, pursuant to Clause 3, says that you'll get residential taxes. But I want to remind Mr. Vice President that the law specifically also proposes in Clause 10 of the bill before us, Clause 10 as Senator Leiter referred to it, but albeit in a disparaging way, Clause 10 is pellucidly clear in setting out the amendments to the Property Tax Act. And it is important, therefore, Mr. Vice President, when you look at the Property Tax Act, the Property Tax Act number 18 of 2009 was amended by Act number 2 of 2015 and number 6 of 2018. And I want to specifically refer to the fact that the Minister of Finance has the ability in the Property Tax Act to also allow municipal corporations to achieve the collection of more than residential taxes. And specifically, the Property Tax Act itself says that the Minister of Finance can give to the corporations residential taxes, agricultural taxes, industrial taxes, and commercial taxes, the 4 categories of taxes. And that, Mr. Vice President, is materially important to answer the submissions and inquiries of my learned colleagues here that said, well, what do we do of a disparity or inequality on the face of it where Mayaro Regional Corporation may be of a geography such that they get 2% on the dollar, as opposed to Port of Spain City Corporation that may get 50 cents on the dollar. And the answer is to be found, therefore, in the Property Tax Act itself. Clause 10 of this bill amends the Property Tax Act. But very importantly, Mr. Vice President, I want to point out that Section 109 of the Municipal Corporations Act, which this bill proposes to set up, Section 109 of this Municipal Corporations Act provides for the statutory fund. And when we're looking at Section 109, allow me to point out, for the comfort of honorable members, that the new 1A subsection being inserted pursuant to this Clause 3, monies of the corporation fund under subsection 1 shall comprise B, revenue from fees, charges, and fines and taxes, including property taxes, collected and distributed in accordance with the Property Tax Act. Let me repeat that. Property taxes collected and distributed in accordance with the Property Tax Act. If you go back to the Part 5 and you look at what is currently proposed, it's true that clauses 77, the new inserted 77, 78, provide for residential taxes, but you must read this law in accordance with Clause 10, which amends the Property Tax Act. And when you get to the Property Tax Act, you will note, Mr. Vice President, that the Minister of Finance has the express statutory authority to provide for residential taxes, for property tax which comes from commercial arena, comes from industrial arena, and comes from the agricultural arena. And that, therefore, is the springboard by which we can calibrate the equation. In other words, then, the Minister of Finance has the proper ability to adjust the scales depending upon the sparsity of residential taxes. Now, Mr. Vice President, that is very important to observe in answering the second observation of honorable members. Honorable members raised the issue about the location or situation of the Minister of Finance in this bill. The opposition supports the view that the Minister of Finance represents a centralization, that the Minister of Finance would allow for politicization, that the Minister of Finance becomes all-powerful. But in making those submissions, the members of the opposition fail to appreciate the Constitution of the Republic of Trinidad and Tobago and the laws by which we operate the whole concept of a Ministry of Finance. We must read this law together with the Exchequer and Audit Act. We must read this law together with the Corporation Sole Act. We must read this law in the clarity of the light that is shed by the Constitution of the Republic of Trinidad and Tobago. So let's go to the Constitution. The Constitution of Trinidad and Tobago sets out in Chapter 8 that there is a consolidated fund. Section 112 of the Constitution sets that up. You can't spend $1 out of the consolidated fund unless you appropriate monies by way of an appropriation bill every year. That's section 112. You cannot spend $1 that you don't have, and therefore you have the ability to ask for more money in a supplementary appropriation, which comes under section 113 of the Constitution. You have a contingency fund set up by section 115 of the Constitution. Parliament may authorize expenditure specifically under section 114 of the Constitution. Who is present in all of these features of the Constitution? The Minister of Finance. Why? Because, honorable senators, I invite you to consider in the whole of government reformation that we're about, that we have to look at whole of government revenue. That is one of the underwriting principles of the Revenue Authority. That is one of the underwriting principles of the Ministry of Digital Transformation. That is the underwriting principle of value for money. But in consolidating money, the Minister of Finance has a role because the Budgets Division at the Ministry of Finance has to look at what money is available to be spent where. Mr. Vice President, we all know that very vivid local expression that we use, champagne taste and Morby pocket. If we want to develop our country, we can have a wish list from now till kingdom comes. How are we going to pay for it is the essential aspect. So in this bill, proposing the introduction of the Minister of Finance, it is in line with the whole of government ideology that we promote. But let's remind ourselves, if you look at section 109 of the existing Municipal Corporations Act, under the power to borrow, the power to borrow is subject to the Minister of Finance's approval. All that we are doing is harmonizing the structures appropriately. Let's deal with another facet of the Minister of Finance that honorable members asked for clarity on. Why, the opposition asked, should the Minister of Finance be in the position where the body of the municipal corporation, that is the municipal corporation itself, established alongside the Executive Council, you have a municipal council, you have an executive council. Why should the terms and conditions for remuneration in section 17 of the Municipal Corporations Act, as it is proposed to be amended by clause 3E as an echo, why should section 17.1 read, the opposition asks, as follows: Mayor, aldermen, councillors shall be eligible for such remuneration as may be determined by the minister with responsibility for finance in consultation with the chief personal officer. Members of the opposition ask, well, what about the SRC? Let me address this situation directly. Under section 120 of the Constitution, followed by section 121 of the Constitution, we have the Salaries Review Commission. That's a fact. Members of Parliament, by way of example, have their terms and conditions and remuneration done by the SRC. How has that worked out? Members opposite complain that they paid $14,000 a month to do full-time work, because this is a lot of work. In the Senate, certainly I can say that this is not a colonial part-time job that we are participating in. The SRC is required to present reports after an exercise that takes decades to have completed. If we're honest with ourselves, the SRC takes decades to complete its role. Compare what is on offer now in the amendments proposed by clause 3E, where we say the Minister of Finance and the CPO, the Chief Personnel Officer, shall set the terms and conditions, the remuneration. The Chief Personnel Officer has two masters in terms of line responsibility: the Minister of Public Administration and the Minister of Finance. Why is that relevant here? Because, Mr. Vice President, what we allow here is an ability to be more agile. The Minister of Finance, the Minister of Public Admin create the job descriptions. They take the job descriptions through the Human Resource Committee of the government. The Human Resource Committee of the government retains external entities to advise on comparators for salaries. That goes to the Chief Personnel Officer. The Chief Personnel Officer looks at it across the spectrum, and you are allowed, therefore, the liberty of moving much faster than the SRC can move and bringing it forward such that terms and conditions can be nimbly adjusted in accordance with job descriptions. Is there precedent for that? Yes, there's precedent for that. Every position that is not prescribed by the SRC having authority pursuant to Section 121 of the Constitution, every position in government is done that way. So there's ample precedent. Senator Dillon asked the question about whether we were going to be able to pay for the services, because we want to have proper participation by people who are competent to act. And therefore, one assumes that you have to have fair remuneration in terms of making it attractive for people to want to serve in these functions. Why serve otherwise? And I'm saying that Clause 3E provides a recommendation for the involvement of the Minister of Finance, which there is precedent for, which there is ample rational reason for, because we are saying now it is an alternative exercised other than selecting the SRC as a mechanism, because the SRC takes too long. And what else is the problem with the SRC? The SRC is a recommendation to the Cabinet. If the Cabinet does not accept the recommendation, it does not pass. It is not circularized by the Minister of Finance, and it never sees the light of day. So, Mr. Vice President, that is an important position for the role and location of the Minister of Finance. Honorable members also asked about whether this was centralization. And Senator Roberts was mocking in saying that I had referred to the fact that the gazetted responsibilities given to me include the responsibility to wind up the affairs of the ministry in which I am in. Let me explain the position of the Minister of Finance versus the Minister of Rural Development and Local Government. The bill seeks to bifurcate certain responsibilities. Matters that concern the financial output, matters in respect of which we need to have a degree of congruity, matters which say let's line it up on a whole of government business for financing, the power to borrow, organizational structures, all of these things where the Minister of Finance has location is not something far different from what exists in the rest of government. Look at the THA by way of example, and I'll come as a matter of point to Senator Dylan Remy's position on the THA and its comparator, and I'll clarify that in a moment. But look at the THA. The Minister of Finance has the responsibility to receive the budgets that come from the THA on an annual basis. That budget is then put into the Ministry of Finance. There's a formula for a minimum percentage that the THA gets that is subject to the dispute resolution mechanism set out in the THA Act, but it is the Minister of Finance that effectively is the hand in law that provides the money to the THA. We are proposing exactly the same measures here. That the budget is produced by each corporation. It is sent to the Minister of Finance. If you look to the amendments that we propose, the Minister of Finance considers those aspects. The Minister of Finance has the ability under the Property Tax Act to adjust, to give more, to calibrate the equation, to add from residential alone to the other categories available. But the Minister of Finance's responsibilities on that side are to bring us in keeping with what the rest of whole of government does. The Minister of Rural Development and Local Government, pursuant to the amendments that we made back in 1959 with the Exchequer and Audit Act, that minister has traditionally been receiving in the last 10 to 15 years anywhere from $2.4 billion per annum to $2 billion per annum. And right now, the distribution of that money is such that at mid-year, you can receive a request for money of anywhere up to $200 to $400 million. And it's never enough money. The Minister of Local Government, in being removed from line authority in this legislation, is to allow the autonomy of the rural development to prosper. Because what we are doing is we're saying we're addressing some very large issues. Number one, we're saying to the corporations, operate full-time. Number two, we're saying to the corporations, operate such that the mayor and the executive council have control over the CEO. Mr. Vice President, last week, I returned a call to a mayor of a corporation. The mayor of the corporation was asking about the release of monies from mid-year, saying that virements were necessary. I said, Mayor, would you please call your CEO and let's do a three-way phone call. The CEO told the mayor that the CEO cannot speak to the minister because it's 4:05 in the afternoon. And the CEO is off the clock. That the CEO only operates during daylight hours and cannot speak to the line minister after 4 p.m. because does not the work. And I'm saying that in my own words. I was flabbergasted to receive that message from the mayor of that corporation. But it is a reality that all of the corporations live with. So the second limb that I'm speaking to is such that the CEO must comply with the rule of the Executive Council. Much like Section 85 of the Constitution says that a permanent secretary who is the accounting officer has to comply with the directions of the minister. And in answer to Senator Mark's question as to who's the accounting officer, the CEO is the accounting officer, and it's so set out in the existing law. The third thing that the corporations are getting is the power to hire. Now, many honorable members asked, why not put local government in the Constitution? And I can answer that in 3 simple letters. UNC. We cannot, pursuant to the Constitution of the Republic of Trinidad and Tobago, make laws pursuant to Section 53 of the Constitution, which says that we make laws for the peace, order, and good government of Trinidad and Tobago, subject to the Constitution, including Section 54. Section 54 of the Constitution says you cannot amend certain provisions of the Constitution set out in Section 54 without special majorities. If you are going to touch the service commissions, if you're going to touch the power and authority to make law that are entrenched, you require a 2/3 majority of both houses in some circumstances, or you require a 3/4 majority and a 2/3 majority in the House and Senate respectively for certain other laws, or a simple majority. But we cannot entrench the provisions that we want to change because we cannot get the constitutional majority support that we require. Now let's go to the tangent that Senator Dylan Remy correctly observed. We have made certain comparators to the THA, but we make that comparator to the THA as it exists now. The THA exists in 2 places in law. One is a creature mentioned in the Constitution in Section 141 of the Constitution onward, 141 A, B, C, D. It just simply says there shall be a THA. It is not an entrenched provision. It is mentioned in the Constitution, and then you have the THA Act itself, which sets up certain roles and responsibilities, including that set out in the 5th schedule to the THA Act. We are borrowing the formula in the existing THA Act, which was passed with a simple majority when A&R Robinson passed it in 1990. And we are saying let's amend the Municipal Corporations Act and 8 other laws and regulations in line with what we can pass. We can only, as a government, pass, because of the UNC, we can only pass simple majority law in this particular incarnation because the opposition will not support the reform that we so desperately require. So what are we to do? Wait another 40 years? Wait another 50 years until Trinidad and Tobago says enough is enough? How has that worked out for the country? That's why I said in piloting, dare to dream and just start. If we look to the amendments proposed in the Municipal Corporations Act, Mr. Vice President, may I ask what time is full time?
Full time is 6:02. You have 16 more minutes.
Much obliged. So when I look to the position of the constitutional reform, Senator Dylan Remy was perfectly correct. We are not referring to the type of amendments that the House considered in constitutional reform to give Tobago autonomy. We're not saying that autonomy is possible because we constitutionally cannot pass it. In any event, we rely upon the confluence of governance, which is why the Minister of Finance is involved together with the Minister of Rural Development and Local Government, and why we give the autonomy to the regional corporations. So I dealt with the regional corporations. Number one, the issue of the CEO. Number two, the full-time capacity. Number three, the ability to hire. And let's touch that issue. We are proposing the amendments that you see, that hiring resides in three places. One, the Public Services Commission, set up under Section 120 of the Constitution. Two, the Statutory Authority Service Commission. Three, the corporation itself. That's the novelty now. We're saying to the corporation itself, take the ability to hire. Why do we have the 12th schedule and the 13th schedule? We have the 12th schedule because if you don't have a service commission supervising the disciplinary aspects of those whom you hire, as we do with the Public Services Commission, as we do with the SASC as a second commission, then you must in law include a process by which discipline is fair and transparent, and that is why the 12th schedule has been inserted to the Municipal Corporations Act, where due process balances the constitutional cautions that we have to have, so capably set out in the Endel Thomas case or Cooper and Barbosa, any one of the cases you want to refer to, we have to observe the constitutional proportionality of the discipline process, and that is achieved by Schedule 12. Senator Leiter said, the sky will fall, Chicken Little will die, effectively, by Section 13. By Schedule 13. Why would the minister need to have the ability in the public interest to step in and perform the functions of the municipal corporation? Well, I'll tell you why. It's in the very arguments that the opposition put forward. On the one hand, they say, you're centralizing, you're not giving enough money, residential taxes is not enough, large geographic footprints will be starved, this is madness, so the opposition theory goes. But on the other hand, isn't it because we must recognize that there will be circumstances where urgency arises that we are going to need the provisions of Section 37? When we look to Section 37, as it is proposed to be amended, and we say that we have to have the ability. Sorry, it's not 37. I'll get the correct section in a moment. When we look to the provisions that Senator Leiter was referring to, and his complaint that the minister is involved and that the Schedule 13 aspects can actually go ahead. Yes, it's 37, subparagraph 3. It is necessary in circumstances of emergencies in the public interest that the minister, coming in with the purpose of the government, coming in with the emergency situations, can treat with and bring money to the table to treat with emergencies. And therefore, there is nothing untoward of having this happen. More so, we must remember the municipal council, as it is managed by the executive council, these are elected bodies, and there is the privilege and freedom of speech. There is also the provision for judicial review in this country. There's the provision of challenge in this country. So we are ensuring that any form of odium that could reside in the minister taking over 13th schedule responsibilities is managed with due process. Mr. Vice President, let's look to the concept of operationalization. But before I get there, Senator Dylan Remy raised the concern, three of her concerns. One was the municipal medical arrangements in Section 42, as is proposed to be mentioned, correctly reflecting concepts of balance. And obviously, I respect Senator Dylan Remy's view, having served in the Regional Health Authority environment. The senator has seen what a transfer from a central body, i.e. Minister of Health, looks like going to a regional body, the RHAs. So if anybody has the experience of saying how a hybrid decentralization can work, Senator Dylan Remy has a lot of experience. But equally so, we're taking now the experience from the local government arm and applying it from a different perspective. But in relation to the risk of zoonosis, etc., I want to remind that the laws of Trinidad and Tobago function as a whole. And if we look to Section 43 of the existing law, the Municipal Corporations Act, Section 43, subparagraph C, standards have to be set by the Chief Medical Officer. So whether you're looking at the Public Health Ordinance, that is Act number 15 of 1915, which is robust law, recently upheld by none other than the advocacy of my colleague, the Honorable Attorney General, when he was in private practice, or whether you're looking at the Animal Welfare Bill, where we deal squarely with the issue of zoonosis and risk and transmission, the Chief Medical Officer is a principal actor in all of these equations and therefore has a standard-setting role pursuant to Section 43, subparagraph C of the Municipal Corporations Act as it's currently constructed, and therefore can harmonize the risks that the Honorable Senator asked for caution in relation to. Change management, which is what Senator Dylan Remy also raised, was something that now falls in line with the operational concerns raised by Senator Richards, by Senator Thiemel. Senator Thiemel made very pointed observations in relation to change management, transitional provisions. Permit me a moment, Mr. Vice President, to say this. And I'm going to touch on, deal with two brilliant perspectives put on the table today, one by Senator Deonarine, one by Senator C. Prasad. They really hit the nail on the head in flagging how long the Auditor General reports or audited financial statements for corporations have been outstanding. Senator C. Prasad went back to show 22 years, 12 years, 13 years. So let's wrap it up. Transitional management, change management, together with the concept of auditing and accounting. Now, we are including in the latter aspect a very powerful amendment. I said in my piloting, the Port of Spain City Corporation is sitting down on $45 million of unspent balances. Why? Because it ain't audit yet. The auditor under the Municipal Corporations Act must come from the central government, municipal corporations, in line with the Ministry of Local Government and Rural Development and Local Government. The auditor has not finished San Fernando, Port of Spain, Arima, so many other areas. Why? Well, the bill provides an option to say the Auditor General, established under the Constitution, can have somebody from the civil side, private sector, appointed as an auditor, produce the audited material, and bring it forward. Why should taxpayers be denied $45 million of needed money to improve their lives because somebody will not do their job. Like somebody would not answer the phone or speak to the line minister at 4:05 on a Friday afternoon. Transitional structure tied into that issue. On being assigned the role of this portfolio, I took with me into this job the role and function that I had carried out at the Attorney General and Ministry of Legal Affairs. Mr. Vice President, in 2015, when this government came in, we need night court, we need more judges, we need more policemen, we will never finish the backlog. When last you hear about night court in this country? What changed? Why don't we need night court again? Because of plant and machinery, people, processes, and law. So we didn't need night court in the magistracy because we merged the jurisdictions into 3 as opposed to 14. We put in professional staff. We changed the clerk of the peace to registrar of the court, and we produced rules of court. And then we went into the caseload and said, chop off all the things you don't need. Take out 8,500 marijuana cases. Take out 104,000 motor vehicle and road traffic and make demerit points. And all of a sudden, the lights came on. Lawyers started going to court since 2016 when we passed the law by computer technology. We stopped spending $26 million in transporting prisoners because they could go to court from the prison. Apply that now to where we are in local government. Plant and machinery, people, processes, and the law. What's the law? The Municipal Corporations Act, together with the 8 other laws that we are amending, and the regulations and bylaws. Immediately upon becoming minister, the ministry went into the retention of a consultant for information technology, one for human resource management, one for engineering and projects, and one for communications. In answer to Senator Drayton, England has an app, we have an app too. It's called Local, L-O-C-A-L. And in the information technology, we built the app already. We're going to beta test the app right now. We're going to run it in two corporations. Every street light, every drain, every overgrown lot, every issue is reported on the app. Click, snap, location. It's then sent to a back room. The back room scrubs what is happening with the position, who is to carry it out, and they're divided into 3 functions. Red light, yellow light, green light. Red light is what is stopped and has no input and is effectively dead in the water. Alarm bells. Yellow light is what is awaiting performance from an external input to achieve the result. And green light is what's going on. In the information technology and digitization aspect that the ministry is already building out, we have determined that it is insanity to not use the Electronic Transactions Act. Why does it take 3 months for a file to leave the corporation, to reach to the bottom of the ministry's desk, to work its way up to the permanent secretary, to find out they're missing a comma and a full stop? That is why the mid-year performance for the local government, PSIP and Development Fund, at 6 months into a 12-month year is at 2.5%. Because the system and processes are what needed reform. This is what I said when my colleague, Minister Kazim Hussain, laid the groundwork in the baton passing from his hand to my hand. He did the groundwork. It's now to operationalize and to bring it in the digital processing aspect. The good news is, it's not the first time we're doing this. If you go and do a company search now at the Ministry of Legal Affairs, and you go to the company's registry, and you're searching for a document, it says there are 1.75 million documents on the site for companies alone. And the good news is, the balance of the abandoning of paper will come under the hand of the Honorable Attorney General shortly. That work has been prepared as the rest of the system goes to work. So we are deep in the operational restructuring, where we look at value for money, where we look at the time that it takes to report and to achieve results. And in the campaign that we are currently on, Mr. Vice President, we are every single weekend and during the week surveying Trinidad. Surveying. We're not cleaning up Trinidad alone, you know. We're surveying Trinidad because, Mr. Vice President, what we are doing is analyzing the needs on a continuing basis. And I want to say that there's good news here because there are infinite number of revenue streams available to corporations if they go into the business of recycling, the business of collection, the business of governance done right, be it in your cemetery or be it in other areas. Because, Mr. Vice President, my humble submission is, people are not afraid of property tax. People want to know that their money is working for them and that they can see the value for money, which is what this law proposes. So, Mr. Vice President, it's a very doable task, but it starts with the passage of the law. There are 15 government senators willing to cast a vote. There are 9 independents who have a vote to cast. We know all 6 opposition said no already. We know that. So don't count them. So it's up to 15 plus 9. At the committee stage, we welcome a significant introspection of the legislation before us. I would just like to say to Trinidad and Tobago, dare to dream and just start. Have faith that this is an achievable mission. I wish to thank the Honorable Prime Minister, the Permanent Secretary, and the hard-working team at the CPC's vision. Last, as I wind up now, I want to thank Senator Clarence Rambarat, as he then was, for being one of the best chairmen of any committee. I worked with Senator Rambarat for 7 years as Attorney General, and his position as a hard-working man is immeasurable, and I pay him public salute today for the excellent work he has done. Mr. Vice President, I believe my time is up, so I will say I beg to move.
Honorable Senators, the question is that a bill entitled An Act to Amend the Municipal Corporations Act, Chapter 2504, the Burial Grounds Act, Chapter 3050, the Cremation Act, Chapter 3051, the Advertisements Regulation Act, Chapter 3053, the Recreation Grounds and Pastures Act, Chapter 4101, the Highways Act, Chapter 4801, the Dogs Act, Chapter 6754, the Property Taxes Act, Chapter 7604, and the Planning and Facilitation of Development Act, Number 10 of 2014, be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Municipal Corporations Act, Chapter 2504, the Burial Grounds Act, Chapter 3050, the Cremations Act, Chapter 3051, the Advertisements Regulation Act, Chapter 3053, the Recreation Grounds and Pastures Act, Chapter 4101, the Highways Act, Chapter 4801, the Dogs Act, Chapter 6754, the Property Taxes Act, Chapter 7604, and the Planning and Facilitation of Development Act, Number 10 of 2014.
Minister of Rural Development and Local Government.
Mr. Vice President, in accordance with Standing Order 66-1, I beg to move that the Miscellaneous Provisions Local Government Reform Bill 2020 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the Miscellaneous Provisions Local Government Reform Bill 2020 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into Committee of the Whole to consider the bill clause by clause.
Mr. Vice President, may I, just for the benefit of all, thank you for moving, for allowing us to move to the committee stage. Mr. Vice President, the government proposes, in light of the fact that there are 111 odd amendments across the 9 laws and regulations under those laws, that we actually take this, because this will be a long exercise, on a subsequent day. So we're proposing to convene the committee on the next Tuesday that we sit, but in the circumstance of at least being able to report to the House that progress has been made, may I crave the indulgence of the honourable senators through you to at least pass Clause 1, which is the short title of the bill.
Clause 1.
The question is that Clause 1 stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill. Minister of Rural Development.
Thank you, Mr. Chairman. Mr. Chairman, in accordance with Standing Order 6814, I beg to move that progress on the bill be reported to the Senate.
Honourable Senators, the question is that progress on the bill be reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate will be resumed. Minister of Rural Development and Local Government.
Thank you, Mr. Vice President. Mr. Vice President, I wish to report that a bill entitled An Act to Amend the Municipal Corporations Act, Chapter 2504, the Burial Grounds Act, Chapter 3050, the Cremation Act, Chapter 3051, the Advertisement Regulations Act, Chapter 3053, the Recreation Grounds and Pastures Act, Chapter 4101, the Highways Act, Chapter 4801, the Dogs Act, Chapter 6754, the Property Taxes Act, Chapter 7604, and the Planning and Facilitation of Development Act, Number 10 of 2014, was considered in Committee of the Whole. However, deliberations in the bill are not yet concluded. I therefore seek the leave of the Senate to resume committee stage on Tuesday, 14th June 2022.
Honourable Senators, the question is that the committee stage of this bill be resumed on Tuesday, June 14th, 2022. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The committee stage of the bill will be resumed on Tuesday, June 14th, 2022. Acting Leader of Government Business.
Mr. Vice President, I beg to move that this Senate do now adjourn to Tuesday, 14 June 2022 at 1:30 p.m. when, in addition to the completion of the committee stage of what we know as the Local Government Reform Bill 2020, we will debate Government Bill number 3, which is a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, and for other related matters. Thank you.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised on the motion for the adjournment of the Senate. Senator Mark.
Thank you, Mr. Vice President. Mr. Vice President, I raise a matter concerning the need for the government to address the poor terms and conditions of nursing personnel in light of pending action to be taken by the Registered Nurses Association of Trinidad and Tobago. Mr. Vice President, it was the Minister of Finance who in his 2021-2022 budget statement on page 112 stated, and I quote, I have also been advised that several nurses in the regional health authorities are employed on temporary contracts. As a result, I have instructed the Chief Personnel Officer to investigate this situation and its implication for pension arrangements and recommend solutions to ensure that the employment contracts of these nurses are regularized. He went on to say, I expect this exercise to be completed by the end of December 2021. Mr. Vice President, today is June the 7th, 2022, almost 6 months after. Nothing has happened. The mamagai continues, the oppression continues, the nurses are under pressure. Mr. Vice President, we understand from our research that there are some 3,400 nurses in Trinidad and Tobago employed in the various RHAs. Mr. Vice President, nurses who have played and continue to play a very important role in the healthcare system, particularly during the pandemic, which we are still experiencing in this country, are still operating in 2022 on June the 7th. The vast majority of them are working on temporary contracts. The Prime Minister also indicated on the 19th of January 2022 that he too was concerned, and he had given his Minister of Health a directive to address this situation. So both the Minister of Finance and the Prime Minister are conscious of this reality. However, Mr. Vice President, the problem persists. The vast majority of nursing personnel are still on temporary short-term contracts. Some, Mr. Vice President, are on one-year contracts. And as their one-year contract ends, they are given 1 month contracts, 2 months contracts, 3 months contracts. Mr. Vice President, how can a government in 2022 expect workers in that particular area of operation, the nursing personnel, to be able to function properly and adequately on a month-to-month basis? When I tell you, Mr. Vice President, this is equivalent to slavery, people get upset with me. But why can we not address this matter? The Prime Minister said it would have been addressed. The Minister of Finance said action must be taken by December 31st, 2021. It is unfair, Mr. Vice President. These nurses who are on month-to-month contracts and 3 months contracts, Mr. Vice President, no vacation leave. They are entitled to no vacation leave. They are entitled to no sick leave. They are entitled to no casual leave. And Mr. Vice President, when they work for 1 year, they take 2, 3, 4 years to get their gratuity. So they are not even receiving their gratuities after they work for 1 year. Why is this being allowed to take place in our country? There's a particular RHA, I wouldn't say where it is located, Mr. Vice President, but we understand from reports that close to 95% of the nurses are operating on 1 month, 2 month, 3 months contracts. How can a government that talks about its love for workers and the nurses allow this thing to persist? This is oppression, Mr. Vice President. The government must act, and they must act now and bring this thing to an end. So I have brought this matter to your attention today and to this Honorable Senate's attention to get a clear and unequivocal commitment from the government as to when they are going to fix this situation. The Trinidad and Tobago Registered Nurses Association, they applied, Mr. Vice President, since 2015 to the Registration, Recognition and Certification Board to represent their workers as the recognized majority union. 7 years after, there is no certificate issued by the RRCB. Why is this? The RRCB reminds me of Rick Van Rinkel. They are sleeping. They are not really awake. And workers, nurses are being taken advantage of. So, Mr. Vice President, I call on the government to take action in defense of these nurses. Bring justice to these nurses by ensuring, Mr. Vice President, that nurses are given security of tenure. Nurses must be permanently employed. We cannot have our nurses on 1 month and 2 month and 3 month contracts any longer. Mr. Vice President, they do not deserve that. Mr. Vice President, they have sacrificed for you and for me and for the people of TNT for 2 years and several months, and yet still they cannot get justice. They cannot be permanently employed. They cannot get security of tenure. They are still working on month-to-month basis. They have no vacation leave. They have no sick leave. They have no pension rights.
Senator Mark, thank you for your question. Your time is over. Yes.
And I call on the government to please give a commitment and undertaking to our nurses.
Point taken, Senator Mark. Yeah. Acting Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, I wish to inform this Honourable Senate that a matter of terms and conditions is part of the collective bargaining process, and it will therefore be unwarranted of me to say anything on this matter. This collective bargaining process is now in train, and once completed, the final compensation package agreed upon will also be applicable to nursing personnel in the RHAs. All of the regional health authorities have contingency plans in place and will take action as required. Thank you.
Senator Mark.
Mr. Vice President, this matter on the motion for the adjournment calls on the government to provide reasons for the delay in the commencement of the Commission of Inquiry surrounding the deaths of 4 commercial divers on the 25th of February 2022. Mr. Vice President, nearly 3 months and 13 days ago, after the tragic events at ParlView Trading Company, where 4 divers tragically and sadly lost their lives, the public is no closer to learning the truth about what happened on that fateful day. What we are hearing is a procedural hearing has to take place before the commission is appointed. What we do know, Mr. Vice President, is that no money has been allocated thus far, and I stand to be corrected by the government, for this commission of inquiry. We know that counsel has been appointed. We know that former Justice Morrison is its chairman. We know an expert has been appointed. We know ParlView has pulled together a battery of legal personnel to defend the company, which is their right. But Mr. Vice President, whilst all this is taking place, the victims, the people who have been affected, the families of the 4 divers are going hungry. Mr. Vice President, ParlView has not reached out to these people. The government has not reached out to these people. So here it is, you are going to have a commission of inquiry, and one of the divers who happened to be extremely lucky to be alive, Mr. Vice President, he has not been consulted by the various personnel involved in this matter. There has been no communication between ParlView and the family members. So what is to take place, Mr. Vice President? If, for instance, nobody is in contact, how can you have a proper commission of inquiry when the victims of this tragedy, the people who have died, their families, and the one who has survived, there is no contact, there is no communication. So how are they going to be represented at this commission of inquiry that we understand is going to start in a short while? Who is going to represent them? Is the government going to provide resources for them to hire their own attorneys, or engage their own experts? What will happen to those people who are not represented at this time? Mr. Vice President, I am asking the government to clear the air, and please don't bring no excuses here this evening about it is sub judice and the matter is before a commission and you can't respond. No! The government must tell the country, are they going to provide financial resources to the family so they can employ lawyers of their own choosing? And are they going to provide resources to these people so that they can employ, Mr. Vice President, their own experts so that they can be adequately represented when this commission of inquiry gets cracking and ongoing, Mr. Vice President. Mr. Vice President, we are very concerned, and the government needs to tell us whether what we have read in the newspaper is factual. I have the newspaper of Guardian. This is the Guardian. Saturday, June the 4th, 2022. The headline reads, Union fears Paria probe may be in jeopardy. 14 occupational safety and health inspectors resign in 15 months. We need the government to clear the air on this matter. Is the probe being compromised? Is there political interference in the authority governing OSH, which is the Occupational Safety and Health Agency? Why so many inspectors have resigned in 15 months, including the chief inspector, Mr. Vice President, who was conducting the probe? Is the government shielding personnel at Paria? Is the government involved in undermining the probe? These are questions that the people are asking, Mr. Vice President. And I raise these matters in the interest of the public, in the interest of the family, in the interest of the dead. The 4 divers who died. May their soul rest in peace. I am defending them and their families to ensure that justice is meted out to them. And Mr. Vice President, I want to serve a warning on this government today. If this government fails to provide the necessary resources to the family of this tragedy so that they can be properly represented, the United National Congress is considering very seriously taking this matter up with the United Nations through the International Labour Organization. We will give the government a few moments to put its house in order. But if the government fails to put its house in order to address this matter, the United National Congress will be taking action to bring this matter to the attention of the United Nations through the International Labour Organization. There's a committee of experts that deals with occupational safety and health matters that protect the lives of workers. We will be writing to them formally if the government does not take action to bring justice to the families who are in stress and undergoing great stress at this time. We believe what is taking place is tantamount to criminal negligence, Mr. Vice President. We believe that
Senator
the government
Mark, you have 1 more minute.
demonstrate care and compassion in this issue, and the government must be more sensitive and sympathetic to the cause facing these families and to get this inquiry going properly and provide the resources to the relevant parties involved so that there can be justice and fair play in this whole matter. So we serve warning on the government, we serve notice on the government to take action, or we will take action in defense of the people. I thank you very much, Mr. Vice President.
Honorable Attorney General.
Thank you, Mr. Vice President. Mr. Vice President, I don't want to unnecessarily agitate Senator Wade Mark anymore, but I have to advise him that he starts his submission and his question on 3 false premises, which I would like to dispel. The first false premise is that there is delay in the appointment of the Commission of Inquiry. There is no delay in the appointment of the Commission of Inquiry. The Commission of Inquiry, as Senator Mark ought to well know, was in point of fact appointed on, if I may just pull up my notes, was appointed in April of this year. May it please you, sir. That is to say, on the 22nd of April 2022. So I hope I've dispelled that false premise. The second false premise is that the procedural hearing has to take place before the Commission of Inquiry is appointed. Well, that's putting the cart before the proverbial horse. Necessarily part of the process of the Commission's procedure, since it has been appointed, is that it will have, in due course, in its own deliberate judgment, and this is not something that the government either can or will deign to dictate, the procedural hearing will be determined by the Commission at a point determined as appropriate by the chairman of the Commission. And in the circumstances that there is an appointed Commission of Inquiry, Mr. Vice President, and that it has been appointed and that there is a procedural hearing to take place in the near future, the question is premised on the fact of a delay in the appointment is entirely false. But may I say further that Senator Mark ought to know that this question, or a very similar question, was asked in the other House. It was asked in point of fact on the 23rd of May, and it was answered on the 23rd of May. And for the benefit of this August chamber, I will read the answer which was given to the question that was asked then. And perhaps Mr. Mark would recall and withdraw the question, since the answer is obviously appropriate and full in answer to his anxiety of today. The answer is, the commissioners were sworn in on April 22nd, 2022, and the commission took effect from that day. Since the commissioners were sworn in, steps have been taken and are being taken, that's the present continuous, are being taken to put the administrative infrastructure of the commission in place, including the establishment of the secretariat for the commission to commence its hearings. The commissioners are currently involved, present continuous, in the pre-hearing stage of the inquiry, which is also known as the investigative stage. During this stage, the relevant evidence is obtained and identified, and the relevant witness statements are prepared. This investigative stage of the inquiry is the lifeblood of the inquiry and prepares and paves the way for the evidential stage of the inquiry, at which witnesses would be called to give evidence. The answer to the question continued. The procedural hearing of the commission is proposed to be held in August 2022. After the procedural hearing stage of the inquiry is concluded, an announcement would be made by the commissioners as to the proposed commencement date of the evidential stage of the inquiry. So that is the answer that is already in the other place, in the public domain, which my learned friend, the learned senator, would be well aware of. And may I just say, finally, the chairman of the commission, and I'm answering now this suggestion, misplaced and mischievous of political interference, shielding persons from the inquiry. The chairman of the commission is a gentleman who is one of the most respected judges produced by the Commonwealth Caribbean. He is Mr. Justice Dennis Morrison. He is a former president of the Court of Appeal of Jamaica. He's a former member of the Court of Appeal of Belize, and he's currently sitting as the president of the Court of Appeal of the Turks and Caicos Islands, in addition to having accepted the post of being chairman of this commission. Mr. Justice Dennis Morrison will bring justice to the subject of the inquiry in his deliberate judgment at the point at which he has determined that he is ready to start. And until he does that, this government, respecting due process, will not intervene to persuade or otherwise suggest to Mr. Justice Dennis Morrison how he should conduct his inquiry. Thank you very much.
conclusion of a great day. Honorable Senators, the question is that this Senate do now adjourn to Tuesday, June the 14th, 2022 at 1:30 p.m. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, June 14th, 2022 at 1:30 p.m.